All right, bro. I know you don't have time to read, but you have time to listen. So I'm gonna tell you about this order from the Court of Criminal Appeals of Texas. It looks like it was. I can't find a date at this moment, but some guy Manzi versus the state of Texas, and it's on appellant's petition for discretionary review from the 14th Court of Appeals, Harris County. It looks like all three judges, it's a unanimous decision. But it says, I join the court's opinion. I write separately to express my reservations about the propriety of resolving disputed material facts based solely upon the relative merits of conflicting affidavits. Basically, he's saying propriety is that the court system is not adhering to the rules. They've got a different plan. They're following different rules that are not accepted. It says, okay, so I'm going to continue. I do not know how anyone, judge or jury, can assess credibility and decide which of two sworn conflicting versions of one event is true based solely upon a written affidavit. So he's saying that the courts are considering these written affidavits and aren't even holding hearings. And it's just written word, and they're like, well, okay, that one must be true. Like, what? How did you do that? Especially in a criminal trial. It says affidavits are widely used in both criminal and civil proceedings to determine if there are material disputed facts, issues, and if so, to define exactly what those disputed issues are, right? So he's saying what the affidavits are used for. However, one affiant says the light was green while the other says the light was red. A hearing at which the witnesses testify, are cross-examined, and have their credibility assessed by the fact finder is usually required. The fact finder is a judge, right? As the Court of Appeals aptly states in this case, in cases where the parties are in substantial agreement on the underlying facts, the use of affidavits may be an efficient means of presenting legal issues to a court for determination prior to trial. Where critical facts are in dispute, however, such disputes are poorly resolved by the use of affidavits. The procedure permits no confrontation, no opportunity to observe, no testing by cross-examination, no inadvertent slips of the tongue, no retraction or recantation of testimony, and no clarification of terms, etc., etc. So you can't, unless parties are agreeing, then you can decide a case based on affidavits, like a summary judgment. And there's some other ways to get a judge to do it or to agree to the terms. But what they're saying is when they're using these affidavits in cases where it's not cool, man. How you gotta do the dirty work now. You gotta look at the people and see what they do on the stand. You know what I mean? The judge has gotta do his job. He's just trying to fast forward everything, some shit like that. And that's what this opinion is about. It goes into some further stuff. Like I said, it's Jonathan Manzi, appellant versus State of Texas, and it's number 2116-01. I don't know the date. I'll find the date. 2002, I guess. It was 2002. So it's pretty interesting. There's some cases in there about hearings and stuff like that, and it might be of some interest. So now that I've inspired you to go read it, hopefully you'll go read it. I'll put the link up. All right.